All right, I hereby call us to order. This is the Code Enforcement Special Magistrate for the City of West Palm Beach. I want to begin by explaining how the process is going to work. Generally, we hear the building cases on the agenda first, and then we call the cases in the order in which they appear on the agenda. However, if you've appeared at today's hearing, your case will be called before those where no one has appeared, but that is only true if you have signed in. So if you have not signed in, please check with one of the officers in the rear of the chamber. Once your case is called, I ask that you proceed to the podium that is on my right-hand side over here. The city will put on its testimony and evidence first. You'll have an opportunity to review this evidence and ask questions of any of the city's witnesses. You will also have the opportunity to testify and present me with your own evidence. Once I have all the testimony and evidence, I will make a ruling. I will either enter a written order today at the hearing or in the next few days, which you'll receive a copy of. If you have any questions as we go through the process, please feel free to ask them. This is not a formal courtroom. The formal rules of evidence do not apply here. However, although this is not a formal courtroom, all testimony given today has to be under oath. So if you're going to testify, or you think you might testify, or there's a possibility that you might testify, I'd ask that you stand and raise your right hand so that I can swear you in. Do you swear or affirm the testimony you're about to give will be truthful and accurate under penalty of perjury under the laws of the state of Florida? Yes. Please be seated. The city can call their first case.
First case number 23316 Poinsettia Avenue, CEBLD 25090838. Number 23316 Poinsettia Avenue.
Good morning, Kevin Pennington, Building Inspector for the City of West Palm Beach. The code case number is CEBLD 25090838. The address where the violation occurred is 3316 Poinsettia Avenue. The violation I observed was exterior renovations. I issued a violation and posted the stop work order on the property September 19th, 2025. The notice of violation was mailed via certified mail and regular mail on May 21st, 2026. It was posted at the property May 20th, 2026, and it was posted at City Hall on May 26th, 2026. The certified mail was delivered May 23rd, 2026. To support my observation of the violation are new pavers, artificial turf, a gazebo, and a masonry barbecue. The photos being shown are truthfully and accurately depict the alleged violation and reflect what I'm testifying to. Permits and inspections are required for the work I observed and for what is displayed in the photos shown. The permits have been applied for, some permits have been issued, some inspections have been performed. Included in my file is a copy of the notice of violation and the affidavit of posting. I have had contact with the owner and intends to complete permits and inspections. City recommends 60 days to comply, $25 fine per day after that. The time to bring the alleged violations into compliance is a reasonable amount of time. I'm submitting the evidence, a copy of this case file, including all documents relied upon.
Thank you, sir, for your testimony. Special Magistrate of the City would like to enter the case file, including the photos and testimony into evidence.
Is anyone here on behalf of the respondent? Seeing no one without objection, I'll accept an evidence. The evidence case file in this case is city's composite exhibit. You said you've had contact with the respondent?
Yes.
Do they understand that they have 60 days to get the permits and?
Yes, we spoke.
Okay. In case CEBLD 25090838, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of FPC 105.1, the failure to obtain building permits, and FPC 110.3, required inspections. Respondent has 60 days to come into compliance or a fine of up to $25 per day may issue.
Number 53244 South Dixie Highway, CEBLD 26010896. Number 53244 South Dixie.
Good morning. Ryan Brown, Chief Plumbing Inspector, City of West Palm Beach. Code case number CEBLD 26010896. The address is 3244 South Dixie. The violation I observed is an interior remodel and a change of occupancy or change of use. I issued a violation and posted the stop work order on the job on January 16th of 2026. The notice of violation was mailed via certified mail and regular mail May 21st, 2026. posted at City Hall on May 26, 2026, and was posted on the property May 26, 2026. Certified mail was delivered on May 23rd, 2026. The observations to support the violation is an interior renovation, installation of a commercial kitchen, and a change of use or change of occupancy. The pictures being shown truthfully and accurately depict the alleged violation that I am testifying to. Permits and inspections are required for the work I observed and for what is displayed in the pictures shown. Permits have not been applied for, and permits have not been issued. So inspections have not been performed. Included in my file is a copy of the notice of violation and an affidavit of posting. I have had contact with the owner, the contractor, and the property manager. They are all aware, the owner of the business, the property manager, and the owner of the property themselves. I've made it clear what they need to do. They have done nothing to accomplish that. They called me right before the hearing. I reiterated again. I did tell them that I was going to give them 120 days or $50 a day after that. So they are aware. So the city is asking for 120 days to comply and $50 a day after that. I am fairly confident that that is enough time to bring the alleged violations into compliance. I am submitting as evidence a copy of the case file, including all documents relied upon.
Thank you, sir. Special Magistrate of the City would like to enter the case file, including the photos and testimony into evidence.
Is anyone here on behalf of the respondent? Seeing no one, without objection, I'll accept in evidence the evidentiary case file, the city's composite exhibit. Okay, it's KCEB-LD 2601086. I make the following findings of fact on law. If I notice is sufficient, I find the property in violation of FPC 110.3 and FPC 105.1, specifically an interior remodel and a change of use. Respondent has 120 days to come into compliance or fine up to $50 per day may issue.
Number 64801 Dreher Trail North, CEBLD 251000845.
Good morning. Peter Valenti, Construction Inspection Coordinator, City of West Palm Beach Building Department. And I've got code case CEBLD 25100845 at 4801 Dreher Trail. This violation was for a dumpster enclosure. I should say 5 dumpster enclosures that were constructed without permits for them. I issued the violation, posted the stop work order on the job site on October 2nd, 2025. The notice of violation was mailed via certified mail and regular mail on 5/21/26, posted at City Hall 5/26/26, and posted at the property 5/21/26. Certified mail was delivered, returned, picked up on 5/27/26. What I observed were the dumpsters that were already constructed. They did not have any permits for them. Pictures being shown truthfully and accurately depict the alleged violations and reflect what I'm testifying to. The permits and inspections are required for the work, and they have been applied for. They have been in plan review. They just have not been issued yet at this time.
Thank you, sir. Special Magistrate of the City would like to enter the case file, including the photos and testimony into evidence.
Is anyone here on behalf of the respondent in this case? Cox Science Center? Seeing no one, without objection, I'll enter in evidence the evidentiary case file in this case, the city's composite exhibit. What remedy is the city seeking?
The city is recommending 30 days to comply and $50 per day after that.
Do you believe that 30 days is a sufficient amount of time for them to bring this into compliance?
Yes, especially considering how long this has been going on and the fact that it is in plan review, just waiting on responses to the plan reviewers' comments.
All right, in case CEB-LD 251000845, I make the following findings of fact and law. If I notice is sufficient, find the property in violation of the listed code sections. Specifically, dumpster enclosures were built without permits. Respondent has 30 days to bring the property in compliance or a fine of up to $50 per day may issue.
Number 11, 935 26th Street, CEBLD 24060584. Number 11, 935 26th Street.
Hi, my name's Lori Higgins. I'm building inspector of the city of West Palm. The code case is CEBLD 24060584, 926 26th Street. Violation I observed is Florida Building Code 105 and 110, exterior remodel and new windows. It's a new stone roof in there. I issued the stop work order on 6/3/2024. The certified mail was 5/21/26, was posted at the City Hall 5/26/26, was posted at the property at 5/20/26. It was delivered at 5/26/26. The pictures that you see up there reflect the true violation. The permits and inspections required to observe is what is displayed on the picture shown. Permits have not been applied for and have not been issued. Inspections have not been performed. I have had contact with the representative for the owner, and he stated that he told the owner several times to get this done. So I recommend 60 days and $50 fine.
Thank you. Special Magistrate of the city would like to enter the case file, including the photos and testimony into evidence.
Sir, can you tell me your name, please?
Edward Page. I'm a non-attorney consultant for the respondent. A permit was applied for, and it ironically came into compliance for applying for a permit on June the 12th.
One second, Mr. Page. Did you say you were an attorney or you're not?
No, non-attorney.
You're not an attorney?
Yes.
And what is your position with Stephen Barros Enterprises?
I'm his agent.
Agent in what capacity?
As a consultant, which the agent letter is on file right there.
Okay. Mr. Page, do you have any objection to the photographs that the
No.
city? Okay.
The only photograph that I have objection to is the electrical box that's there, and a permit was applied for that. The only thing that we're discussing is the facial that's on the front, and I was indicating that he did take a long time to apply for a permit. They applied for a permit, but they didn't submit the necessary documents to go along with it,
All right,
so the permit was canceled.
hold on one second. The city isn't pursuing anything electrical at this point, right?
No, sir.
Okay. All right, I'm going to accept in evidence the evidentiary case file, city's composite exhibit. All right, so as to the exterior remodel, what's the status on that?
The permit was submitted for your records on last Thursday. I believe that was is that the 12th? They had to come into compliance by June the 12th. Didn't come into compliance, but they have started the permit process. Depending on, I think she said maybe 60 days. I would like at least maybe 90, but I believe I could probably get it done in 45. It's just a simple facial. There's no electrical, nothing else has been done. I did have a conversation with one of the building officials. We have plans that have been submitted, and the solution is to get a certified engineer to come out and check the work, make sure it was done to Florida Building Code once those plans are accepted.
The city's asked me to give you 60 days. Is that a sufficient amount of time for you to get this in
If you
compliance?
could give me 30 more days, that would be awesome.
What's the city's position on 90?
I don't have a problem with that.
90 days it is.
Thank you.
All right, CEBLD 24060584. I make the following findings of fact and law. I find notice is sufficient to find the property in violation of the two listed code sections for an exterior remodel. Respondent has 90 days to come into compliance or a fine of up to $50 per day may issue.
It should be out on the table out there. I don't have it up here. Number 12, 5600 North Flagler Drive, 509 CEBLD 24070610. Number 12, 5600 North Flagler Drive, 509.
Good morning.
Good morning.
Me. I just received this notice last week.
Hold on a sec.
Oh, I apologize.
The city goes first.
Oh, I didn't know.
Yeah. Were you here to be sworn in, sir?
No.
Okay. Just for anyone that arrived late, the city presents the testimony and evidence first, then you have an opportunity to respond and ask questions of any of the city's witnesses and to review any of the city's evidence, after which time you can present your own evidence. If you are going to testify and you haven't been sworn in, please rise, raise your right hand, and I will swear you in. Do you swear or affirm the testimony? You have to stand up. Do you swear or affirm the testimony you're about to give will be truthful and accurate under penalty of perjury under laws of the state of Florida?
Yes.
All right. Go ahead.
Hi, I'm Lori Higgins with the City of West Palm Building Department, Building Inspector. Code case CEBLD 24070610, 5600 North Flagler, Unit 509. The violation I observe is Florida Building Code 105 and 110, working on flooring in a tankless water heater without a permit. The permit, a stop work order, was posted on the 15th July on 2024. The mail, certified mail and registered mail was 5/21/26. Posted at City Hall was 5/26/26. Was posted on the property 5/21/26. The certified mail was not picked up and it was returned on 5/31/26. And the observation again is working on the flooring and the tankless water heater. The pictures that you see are the true violations. He had an ongoing renovation and just extended it to these items without a permit. He has not applied for a permit and has not been issued, and no inspections have been performed. I have had contact with him. He asked for more time because he's a doctor and goes back and forth from New York. But I had reached out to his contractor several times, and they always promised me they would get a permit in, which they did, and then they didn't ever do anything about it.
I speak now.
So I'm asking for 60 days to comply and $50 a day.
Thank you for your testimony. Special Magistrate, the city would like to enter the case file, including the photos and testimony as evidence.
Yes, sir. Can you tell me your name, please?
Dr. Anthony Ippolito. I only found out about this a week ago. The guy that I was using to do the GC work, he was very difficult to deal with, and I had no idea that any of this was going on.
Can you spell your last name for me, please?
Sure. It's IPPOLITO.
And what is your relation to 5600 North Flagler Corporation?
Excuse me?
The owner of the property is...
That's me.
So are you the owner of that corporation?
I am.
Yeah.
And I didn't know this was all outstanding. I'm here.
Before you go on, I just have to know whether you object to the photographs or documents the city would like to put in evidence.
Some of the photographs that they have of the bathroom, so we have a permit for the bathroom, so I don't know why they're there, but it's really not that big a deal. I understand about the flooring, and I understand about the heater. Why there are pictures of the bathroom.
They're not concerned. The only issues before me today are the flooring and the water heater.
Okay.
All right. I'm going to accept those documents and photographs and evidence as city's composite exhibit. All right, sir. The floor is yours. Go ahead.
So anyway, I only found out about this last week or 10 days ago because I'm only here once or twice every 2-3 months. I bought it for retirement, which I won't be doing for another 2 years. And I just, like the lady said, I'd like 60 days to rectify the situation. I have a contractor coming today, and I just have to find out where to get the necessary permit paperwork, and I'll have it rectified. You know, I've been a doctor for 32 years, and I've never had an issue of compliance, and I don't want to start with this as being my first. And $50 a day, if we could waive that.
Well, what the city's asking me to do is to give you 60 days to come into compliance. If you don't come into compliance in 60 days, they're asking me to set a fine at $50 per day after the 60 days.
No, I'll be done. 2 weeks.
All right.
But 60 days I'll take.
I'll give you 60 days.
Thank you.
All right, CEBLD 2407061. I make the following findings of fact and law. If I notice is sufficient, I find the property in violation of listed code section, specifically flooring and a water heater installed without a permit. Respondent has 60 days to come into compliance. If compliance is not achieved, a fine of $50 per day may issue. Good luck, sir.
Thank you very much. Appreciate it. Where do I go? I'm done.
Yes. Number 1, 1245 25th Street, CE 260553999. Number 1, 1245 25th Street.
Good morning, Your Honor. My name is Neil Maharaj, City of West Palm Beach Code Enforcement Officer. Case number is CE 2605-5399. Property is 1245 25th Street. Violation was issued on May 21st, 2026 to the owner of Sailfish Real Estate, LLC. I conducted a reinspection as of yesterday, June 16th, and noticed that the landscaping company was on site and about to begin correcting the violations. As a result, the following violations remain not in compliance. 94-446-2-E for edging of all the perimeter of the property, and 94-316-D-1 job site maintenance. It is currently under construction for the gas station there. 18-106-B, 18-106-K for overgrowth on the property throughout. Certified mail was successfully delivered on June 4th, 2026, and the NOV was posted May 22nd, 2026, and the affidavit of posting was notarized into the case files. So I've spoken with Mr. Singh here, who's representative of the property. Like I said yesterday, the landscaping company was there to correct the work, but I was unable to confirm it completed. So I am seeking 10 days to comply or a $50 fine per day.
Thank you, sir. Special Magistrate, the city would like to enter the case file, including the photos and testimony into evidence.
Sir, can you tell me your name, please?
Bisram Singh.
Mr. Singh, do you have any objections to the documents and photographs the city would like to put in evidence?
No, I don't.
Without objection, so admitted. So, Mr. Singh, what's the status of your property, sir?
Okay, it's a new store that we will build it, so the contractors were responsible for maintaining. They had some issue and they stopped work, so they left it on, and they didn't inform us. Or I would have a regular landscaper go and take care of it. I'm sorry about that, but yes, our landscaper took yesterday, they went in, they should be completed by now and doing all the work. Like I said to the inspector, if there's anything more to be done, let me know and we'll take care of it.
Do you believe that you can get this accomplished in 10 days?
Oh yeah. It should be done by now.
But job site maintenance, what specifically were you concerned about?
It's the overall, there was like a little bit of construction debris in the parking area where the pumps are actually situated. And because it's currently under construction still, just the overall maintenance of the property. So including the overgrowth, the edging, the trash, and the sediment control.
Mr. Singh, do you understand what you need to do?
Yes.
Okay. All right, in case CE 2605539, I make the following findings of fact and law. If I notice is sufficient, I find the property in violation of the listed code sections. Give the respondent 10 days to come into compliance or a fine of up to $50 per day may issue. Good luck, and please do check in with the code officer.
Thank you.
Thank you.
Number 8, 230 31st Court, CE 2604523. Number 8, 230 31st Court.
Morning. Tony Apicella, Code Enforcement Officer for the City of West Palm Beach. Case number CE 26045230. property located at 230 31st Court. Your Honor, a complaint was received on March 20th, 2026 regarding multiple potential violations at this property. On March 31st, 2026, I inspected the site and confirmed the following violations existing. 94-482-A, parking requirements. There's a gravel driveway. It's not made of a permeable substance. 94.
A non-dusting surface?
I'm sorry?
On a non-dusting
A non-dusting surface. I think I've said it enough times that it's probably. 94-71-C, outdoor storage. I viewed several hurricane panels, stepping stones located in the front of the property up against the window, or I'm sorry, underneath the windows. 94-442-E, landscaping of swales and parkways. This has to do with 31st Street. It's sort of a unique setup. This gentleman's home faces 31st Court, which the rest of them on 31st Court, that would be considered the alley. So the back of his home is 31st Street, if that makes any sense to you. And finally, 78-6, address numbering standards.
What is wrong with the landscaping on 31st Street?
There's a picture, Your Honor, that there's no landscaping in the parkway. The code requires that it be, there it is, that it be sod or approved ground cover.
Okay, go ahead.
And finally, where was I? 78-6, address numbering standards. Apparently there is a hold put on this location because there's a half address. The gentleman does have a valid rental license for, I'm assuming that would be his back thing. Unfortunately, the lady that is responsible for assigning a new address has been on vacation. So as soon as she returns, she can assign an address, and he needs to put the numbers, as I explained to him in his representation, will have to be posted on the rear of the property.
There isn't an official address for this property?
I'm sorry?
There's no official address for this property?
There is. It's 230 31st Court. However, it also has 230 and a half 31st Court. And at some point, the city changed. There are no longer, or half addresses are no longer permitted. I think it has something to do with the digital use now for police and fire.
So it should be 230 31st Court.
That's the front of the house.
So what should the other part?
The back, in other words, the back building will have a separate address.
Okay. But
And
there isn't
there
isn't one issued yet. Is that it? Is that what we're saying?
Correct.
Okay.
So she will issue one, and then it will be the respondent's responsibility to post it. Okay, I explained the violations to the respondent, who stated at that time that he was not going to comply. He has since had a change of heart. A notice violation was posted on April 24th, 2026, and first-class mail and certified mail was sent on May 14th, 2026, and certified mail was received on May 26th, 2026. On May 21st, 2026, at the request of the respondent, I met him and his representation at the property. They requested a walkthrough. Myself and Code Officer Raphael Forrester attended. All the violations and required corrective actions were reviewed and explained. A compliance deadline of June 5th was established on the notice of violation. I re-inspected the property on June 5th, June 10th, and June 15th, and confirmed that the violations that I just read had not been corrected. The city is requesting for 94-71-C outdoor storage, 94-442-E, the parkway, and 78-6, the address designation, 60 days to comply or $100 per day until compliance is achieved. For 94-482- subsection A, the gravel driveway of a non-dusting surface, the city is requesting 365 days to comply, or $200 a day until compliance is achieved. Your Honor, I do have representatives of the engineering department present and planning and zoning, and if you'd like, they can go into more detailed explanation as to why we're requesting the 365 days.
Well,
City does, I'm sorry?
Let's wait on that.
Okay. The city does believe that that time frame is adequate for the compliance to be achieved.
Thank you, sir. Special Magistrate, the city would like to enter the case file, including the photos and testimony as evidence.
All right, can you gentlemen tell me your names, please?
Davis Taylor, Davis Harding Taylor.
And John Cleary, his attorney.
I'm sorry, your name was?
John Cleary, C-L-E-A-R-Y.
Do you have any objections to the photographs or documents the city would like to put in evidence?
No, we'll stipulate.
That objection so admitted. The floor is yours.
Mr. Harding has complied with, I would say, 90% of the violations up to this point. The outdoor storage, I think, has been completely resolved. The problem with the landscaping of the swale on 31st Street is that there's no curb there anymore. The curb has been destroyed, so he put in railroad ties. The city wanted him to take the railroad ties out, but if he takes the railroad ties out and he puts sod in, it'll wash into the street. And we've spoken to Tony about this, and he said, well, at some point the city will have to repair that, but until they do, he's not going to be able to take out the railroad ties or even landscape that swale. And it's sort of a catch-22. He can do it now to comply it, but it's just going to end up being the same problems it always has been, which is that curb is broken. He can't fix that curb, and until that curb is fixed, he really can't come into full compliance.
Your Honor, his objection at first was that there's blue markings along 31st Street. So I verified with the engineering department, hence their presence here today. That was simply to mark a gas line, I believe, that there is no planned work to be done on 31st Street. The email should be in the case file here. An email was sent to Public Works, and a work order has been created to redo the curb that he's speaking of. However, I was told...
Does the city agree that he can't complete the sodding in the absence of the curb being fixed?
No, Your Honor. The city does not agree with that. But in an opportunity to dispel his concerns, we have put in the work order, and the work order will be generated, but at the city's request, the road ties or railroad ties, of whatever you want to refer to them as, have to be removed before the city will conduct any work there.
So when are we moving the rail ties?
He can remove the rail ties. If he removes the rail ties, he cannot sod. The sod will just, the soil will wash into the street. It's at an angle, and there's nothing to keep the sod in.
I've tried 5 times.
So I understand that there's now a work order put in, but I'm familiar with the city's work orders. That could be 12 to 18 months. And right now, for him to remove the railroad ties, that's going to create more of a problem.
Well, the city doesn't seem to agree that you can't sod it in the absence of them fixing the curb.
If there was a time frame for when that curb would be fixed, we would be able to work within that time frame. He would have those railroad ties removed, and we would work within that. In the meantime, if those railroad ties are not in place, all the soil will wash into the street once he takes those railroad ties out. And then he's got to dig all that sand out from the street and put it back in while they attempt to put in a curb for the next year and a half.
Do we have any sense of when the curb is going to be fixed?
That information I do not have. However, Your Honor, the curb is there. It's just not solid. There is broken areas. I will, stipulate that. But in order for him to comply this, it's obvious that there was some sort of material put down which built the would-be sodded area up higher than the curb. So if you were to remove the ties and remove some of that and make it level again with the neighbor, you can't see it in the picture.
I think I'm going to need here. You said you brought the engineering folks?
I did.
I think I'm going to need to hear. Hi, can you state your name, please?
Good morning. I'm Suzanne Bergman, the Assistant Director of Engineering for the City of West Palm Beach. So I am currently the project manager for the North Flagler Drive project. The first thing I want to mention is I do have a set of plans with the project limits. We are going to be touching 31st Court side, but not the 31st Street side. I just want to clarify that piece of it. The other item regarding the sodding of that area there, we have areas throughout the city that do have sod right next to the roadway, and the sod actually stabilizes that kind of dirt area. So I respectfully disagree regarding the sod not providing stabilization for the dirt adjacent.
So in your professional opinion, this area can be sodded in the absence of the repair?
Correct, yes. In my professional opinion, yes.
Okay. All right, thank you. Do you have any questions for the expert?
No, I disagree, but I don't have the credentials. Thank you.
Sorry.
All right, so so that's the swale. You said the outdoor storage is largely fixed. I guess you're not going to disagree with the city giving you a year on the parking requirement?
No, he's actually sodded that area and is going to put pavers in there and is going to be applying for a permit for that because he's trying to figure out a way to save the tree, to have it permeable and do all those things. His original idea was that he didn't need to save it because Chattahoochee was not non-dusting. He's changed his mind. We are now up to speed on that. He's going to be applying for a permit and he has time for that. So a year is a lot of time, but we'll take it. Because at that point, 31st Court will be
I got to say, I've been doing this a while. That's one of the largest time frames I've seen the city
to
recommend.
do the whole street, so I figure at that point, we will have a permit in place and we'll figure that out.
Speak to me about this numbers thing.
Okay, so the city attaches new numbers. The city's going to attach new numbers. We email Ms. Puel, who is the person who signed attach the new numbers. She's out. She could do it in a day, but she just didn't have to be in last week or this week. So next week she'll apply or she'll figure out how to unify this under this different number, and then we'll paint those numbers on the back gate or we'll put them up there in a way that the city is appreciative of with high enough letters and lighting and all that.
I guess my question for the city attorney is how can I hold them in violation if the city hasn't issued a number for them to put up? So what are they violating?
Yeah, and I would, I'll defer to the code officer on this one if you want to continue this matter in light of the circumstances, the numbering matter only.
I think it will be resolved in that particular case. I think this will be resolved next week either way.
Yeah, just as a practical matter, I can't hold your client in violation of not putting up a number that doesn't exist yet. Just as a question of due process and fairness, I don't think I can do that. All right, so is there anything else you want to tell me?
The only thing other than that is once Mr. Davis decided that he wasn't going to fight this and that he didn't have the basis to fight it, he's been compliant the whole time. He's 70 years old. He did most of this work by himself. So he's a worker bee. He's doing all that. We would ask for 60 days on the outdoor storage and the landscaping to pull out the railroad ties. And then if not, $50 a day, please.
I'll give you, on the landscaping, I'll give you 90 days just in case on that one. I'll give you 60 days on the outdoor storage since you're basically done with that anyway. I'll give you the 365 on the walkway. I'm not going to make a finding of violation on the numbers at this point. If they issue the numbers and it doesn't come and he doesn't put them up, then file a new violation. But I can't violate them for something that doesn't exist. All right, in case CE 260-45230, I make the following findings of fact in law. If I notice is sufficient, I find the property in violation of 94482A, which is the parking on a non-dusted surface. Respondent has 365 days to bring that into compliance or a fine up to $200 per day may issue. As to, I also find the respondent in violation of 9471C, which is the outdoor storage. I'll give the respondent 60 days to bring that into compliance, or a fine of up to $50 per day may issue. And as to I find the defendant in violation of 94442E, which is the landscaping that needs to be sod or another approved surface. I'll give the respondent 90 days to do that, or a fine of up to $100 per day may issue.
Thank you, Your Honor.
Number 9, 1210 Palm Beach Lakes Boulevard, CE 26045269. Number 9, 1210 Palm Beach Lakes Boulevard.
Your Honor, the resident, the property manager was here, but he left, so I don't know if I don't want to take the time of everybody else's.
Well, you're up, so let's go.
Okay. All right, good morning. My name is Alessio Carulli, Code Enforcement Officer for the City of West Palm Beach. This matter was referred to Code Enforcement by the Sanitation Department. Upon investigation, it was determined that no tree alteration permit had been applied for or issued for the subject property, in violation of Section 94-448-D-1 of the City Code. A review of the current site conditions and historical records revealed that a total of 14 trees had been removed from the property. Additionally, I observed evidence of tree abuse, as multiple trees had been removed from the property, constituting a violation of Section 94-446-2-C of the City Code. During the inspection, I also observed a large accumulation of trash and debris on the property. The premises were not being maintained in a clean and sanitary condition, in violation of Section 18-106-A of the City Code. The property at 1210 Palm Beach Lakes Boulevard was observed to have the following violations that are still in non-compliance. So it's 94-448-D-1, which is the tree alteration permit. No tree alteration permit had been applied for or issued for the subject property. 94-446-2-C, tree abuse, observed multiple trees, total 14 were cut and removed, and 18-106-A, which is clean and sanitary, observed the building not to be in a clean and sanitary fashion.
Specifically, what do you mean by that?
There's, in the pictures, there's a large pile of trash and debris. There's mattresses, there's all trash, fecal matter was there. So the city issued a notice violation to the property owner, which identified the violations, contact information, and notice of today's hearing. The notice of violation and notice of hearing sent via certified mail and regular mail on 5/6 of 26 and received and signed on 5/18 of 26. The notice of violation was issued at the property on 4/30/26. The notice of violation was hand-delivered and signed by the property manager on 5/1/26, and then a signed notice of violation is in the case file. It's dated 5/1/26. The photos were taken at the initial investigation and when the property was revisited. These photos accurately and truthfully depict the violations observed during the investigation. I've had limited contact with the property manager, who stated that the violations were being addressed. So for Section 18-106-A, which is the tree debris, trash and debris on the property, the city is requesting 10 additional days to achieve full compliance or be subject to a fine of $100 per day. For the violation of Section 94-446-2-C, which is tree abuse for cutting down 14 of the trees, the city is asking for a one-time fee of $250 per tree. And then for the violation of Section 94-448-D-1, the city is requesting 30 days or a $100 a day fine. That's for the tree alteration permit. And then the city believes that this time requested is more than enough time for the owner and property management to achieve compliance.
Thank you, sir. Special Magistrate City would like to enter the case file, including the photos and testimony and evidence.
Is anyone here on behalf of the respondent? Without objection, so admitted. So you're looking for $250 per tree. Is that because the city believes that it is irreversible? Essentially, they killed the trees?
Correct, yeah. We asked him to supply something from the landscaper or an arborist report, but he has not yet gave us any of that information.
And we're talking 14 trees, right?
Yes, sir.
And they removed all these trees without a permit?
They removed all of them.
All right, in case CE 26045-269, I make the following findings of fact and law. I find notice sufficient to find the property in violation of the listed code sections. As to 94448D1, I order the respondent to obtain a tree alteration permit within 30 days or a fine of $100 per day may issue. As to 94446-2C, I find that the respondent removed 14 trees. That said removal is irreversible, irreparable in nature. I hereby assess a fine of $250 per tree. And as to 18106A, I find trash and debris all over the property, and respondent has 10 days to bring that into compliance. What fine did you ask for on that one? Was that $100?
$100, yes, sir.
$100 per day.
Number 7, 428 55th Street, CE 26055-346. Number 7, 428 55th Street.
Morning, Tony Apicella, Code Enforcement Officer of City of West Palm Beach. Case number CE 2605-5346. Property address is 428 55th Street. On May 11, 2026, I received a complaint alleging that the property located at 428 55th Street was being used as a rental without a valid rental license and without a certificate of use. These allegations indicate a potential repeat violations of Section 22-441 and 22-32 of the City Code. On the same date, I conducted a records research confirming that the property had a previous violation for the same offenses under case number CE 211-00146. That case reached compliance on December 31st, 2021, establishing the basis for the repeat violation status. A notice of the violation for the repeat violation was created on May 12, 2026. The property was posted on May 13, 2026 by Code Officer Raphael Forrester. Certified mail and first-class mail was sent to the respondent on June 5th, 2026, and the mail was received on June 9th, 2026. As part of the historical case record, the respondent submitted a handwritten statement to the city on October 8th, 2022, in which the respondent stated that the property would not be rented. The current observed conditions contradict that prior written assertion. During this investigation, the complainant reported that multiple individuals were renting rooms within the selected residence and provided an unsigned roommate agreement, which is in the case file, and email exchanges about the lease with the owner, also in the case file. During my inspection, I photographed multiple pieces of mail and documents addressed to different individuals at this property, which is consistent with the rental activity occurring without the required city approvals. Based on all the observable evidence and historical documentation, the property was operating without a rental license and without a certificate of use. This establishes a repeat violation on the prior special magistrate order issued in the case CE 211-00146. The city respectfully requests the following: a one-time fine of $250 for the violation of 22-441, the rental license for being required, and a retroactive fine of $100 per day for the violation of 22-32, the certificate of use required. The fine period begins on September 1st, 2025, which is the date the tenant took possession of the property, and ends on June 16th, 2026, the date the inspections were completed and the rental license was issued. This period totals, by my calculation, 288 days of non-compliance. The total retroactive fine amount is therefore $28,800.
Thank you for your testimony. Special Magistrate, the city would like to enter the case file, including the photos and testimony to evidence.
Sir, can you state your name, please?
My name is Anthony Sawaya. I'm the owner of that property. I have some objection about the statement of the officer here. In 2022, as you mentioned, that I have repeated violation. That time when I bought the property, it was neglected and I did fix it. I went down to the town to here and I did sign that it's not rented and I cleaned the property very well. And at that time, I've been in that room more than twice to get the approval from the historical preservation. I was dealing with, I believe, Frederic Mettner on a daily basis. And I got the approval to have this house to add cabana, which I haven't done it yet. And I gave also to the city or to the historical preservation 200 square feet in the front of this house that to bring it back to the original preservation. And they were all pleased. And so since 2022, from that statement I made, the place I applied for permit, I did the renovation, and it was substantially completed in end of 2024, early 2025. The place was vacant all the time.
The city is not accusing you of doing a renovation without a permit. The case before me is a rental without a, what the city is alleging here is that you have rental people on the property without a rental license. That's what you need to speak to. But before you can get to that, I just want to know, do you have any objections to the documents or photos that the city would like to put in evidence?
Okay. Your Honor, it was vacant, the property, until I got someone to share the house with my family. That person you're referring to, I knew her from I was a volunteer on the Palm Beach Hotel condominium for 4 years. And she always coming to me, ask me for help. And first time she came to me, said, I need to breach a lease. And what can I do? I said, try to talk to the landlord to give you 60 days. Then she kept coming to me, she wants a place, and she cannot afford it. At one point, I said, look, if you need it for a month or two, I have a house empty. I can have you come in. She said, it's too far. Few months later, around in 2025, she called me. She said, look, I'm in trouble. Can I come and see this house? I said, no problem. She came in with her mother, and I was like a friend with her, but very limited, just as being the president of the board. And then she said, okay, I can pay you so much. And I said, Claudia, how long are you gonna be? She said, maybe a month, maybe two. I said, fine. Then all of a sudden she asked me for a lease. I did Google to find anything because that property, I never listed it. I never intend to lease it. It was for my family. And then she came in. She never used the place. She only comes once every 2 weeks. And she does take her mail and change her clothes and leave. Only I find out from my son, who lived with her over 4 months, last 4 months, that she slept maybe 3 or 4 times. She came in very late, she's on the phone, and finally she said, I need my deposit. I gave it to her, I settled with her, and then I found out at the door there is a certified letter from the city, and I went directly to the city hall, and I applied for license. Even I don't need the license. My intention was to help that lady. She said, you have a cancer. She said, you have no money, and I tried to help, and I got myself in trouble, I guess, with the city.
Well, you
I
you
also
certainly
have
did,
brought
'cause
someone,
no matter,
Your Honor.
sir,
Yes, sir.
there's no mental state for renting a property. You either did rent it or you didn't rent it, and you didn't. And it sounds to me like you did rent it, and you rented it without a license. And this is the second time that you've done it. You can't rent property in West Palm Beach without a license.
I do have other property on 53rd Street. It's Airbnb, and I know what it takes to do that. I do know. There, I did not know what to do. When she asked for release, I did Google to see if I need anything like that. Honestly, I didn't pay too much attention to the details, to be honest with you, Your Honor. However, I had brought someone who's familiar with the property with me, if you allow me to introduce her, that no one was on this property ever except that lease. And you're talking about 228 days, or I don't know the penalty you're talking about. The place was empty, and I'd like to introduce Michelle Cohen to express that no one was in the property. The only time I have the property is those few days. Thank you.
Hi, my name is Michelle Cohen. I actually served on the board with Anthony for a building on Palm Beach Island that we both own condos in. I wanted to testify that I don't understand the 2021. I don't think there was ever a tenant in there in 2021. I think that was maybe from the previous owner.
I'm not gonna
but
go back
what
to
I'm
that.
testifying.
Hold on, ma'am, just for clarification. That finding was found by another magistrate. That's law of the case, that there was a violation back then. That's not before me today, and I'm not gonna, I can't unwind it.
Yeah, because basically
what I need you to testify to is the questions of this case.
Okay, so I can testify that from March of 2023 up until the week before Thanksgiving of 2024, I was going in the house regularly, consulting as an interior designer for paint. It was uninhabitable. When I went in there in March, there was no kitchen. So I don't know how a year before there would have been a tenant in there. But again okay.
What I'm concerned about is
there was no one in there, and I was there twice per week picking up packages and mail for Anthony, because we were kind of dividing and conquering as board members. Regarding the mail, there were many random names on the mail, but no one was residing in the property.
When?
Unfortunately, I wish I would have known later because we weren't on the board. This particular person that he signed a lease.
When was no one residing at the property?
What I witnessed, there was no one residing in the property from March of 2023 through November of 2024. The other thing I wanted to just attest to was the person that the lease.
That's not even an issue.
Sorry. Yes. The person that was on the lease, and that also I know during this time, the intention of redoing the house was.
Stop for a second, please stop for a second. The time period we're concerned about was when?
The complainant stated that she took ownership, and which is evidenced by the lease, was September 1st, 2025.
Right,
yes,
so
and sorry, and I gave too much background information.
Yeah.
During that period, the intention was always that his family would move into that property, because there was another property that was Airbnb'd. Never any intention.
Can you speak to the conditions of the property?
The conditions of the property
25.
after that was that it still was not quite ready for someone to move into. It may be relevant or not, but this person, I was not able to convey to him. She's on a do not rent list because there's a background of suing and taking advantage of people. He made a mistake.
Ma'am, you were telling me a lot of things that I don't need to know. What I need to know is, what do you know about the residency in the apartment after September 2025?
His son, his sister, who was burned, was living in the property with a cousin, and his son periodically lived there, and that was the intention, as far as I know, for that house to always be occupied by the family, and that a woman who said she had cancer and cried a story asked if she could be in the house with his family members. That's what I know. And
so you don't know whether she was or she wasn't?
I'm sorry, what?
You don't know whether she was in the property or not?
And I know that she was not consistently in the property, and that there were summons issued to the address for legal matters, and that's why she wasn't there all the time. But that's all I can attest to.
Okay, thank you.
Sorry.
It's okay.
Your Honor, I have one more thing, if possible. I have an affidavit from my family who lived there when the tenant was there. Is there a way I can?
You can show it to the code officer and the city attorney.
Just to clarify also, Your Honor, that my son lived there over 4 months when that lady was there too. My sister, and ultimately on next 3 months, they're gonna move into the house. I never listed it, I never put it for rent. It was a favor I'm trying to do, and I got into trouble with it, I guess. And I went right away, did a license as requested, and
Hold on a second.
here I am.
Let me let the city attorney review your document. Do you have any objection to this?
Yeah, the city objects on the basis of hearsay.
I don't suppose you brought any of the people that signed this.
Pardon?
Are they here to testify?
Yeah.
The people that signed this?
Yes, and I put.
Are they here in this room?
No, they're not here. They're not here.
Oh, they're not here. They're in New York, actually. That they move in here in 3 months to the house. Same people. They live there. My sister, the room's still full with her stuff. She's
This
living
is,
there.
without them here to testify, this is hearsay.
Oh, well, can we do it for next time? I can bring them in.
No. So the city is asking me to fine you $250 for not having a rental license and to fine you $100 a day beginning September 1st to June. Why June 16th? Are they in compliance at that point?
As of yesterday, the rental license has been received, printed, yes.
So that would be a fairly substantial fine of $28,800 plus the $250. Do you want to speak to that?
I really think, Your Honor, it's unfair for simple reason. Even I did not know. I did it as a favor. I never listed the house. The woman always come to me, and I called my wife. I said, the woman with cancer, because my wife has cancer as well. She said, help her out. I did it out of my heart, not from my brain. And then she insisted she wanted a lease. And when I gave the lease, I thought about it. She sent me lease from different person telling me how can I break it. And I said, go talk to them to give you 60 days. I start adding up. And then my son telling me there are people coming at the door asking for her to serve her paper. I start putting everything together, and I find out from the Palm Beach Hotel condominium she's on no rent list. And this is where I am. I think I don't deserve to be penalized. I understand that I made a mistake, but look at my other property. I have Airbnb, I have everything is paid, taxes, everything perfect. And I served 4 years in that Palm Beach Hotel as volunteer. So I was always given and given and given. And I feel I need some help.
I have a question. Are you required to have a rental license to have relatives live in your house?
Ma'am, I don't do cross-examination.
Hey, well, no, because what I was getting at was that I think it's unfair to do that much in a fine because the woman has already moved out. She didn't live there during that lease period. So I do feel like that's an excessive fine. That's all I was going to say, that it's excessive because she's moved out, she isn't there, and he doesn't even need a rental license because he's not going to be renting it. His relatives are living in there for free.
All right, thank you. Okay. I'll give the city the last word here. Why is the city pursuing such a substantial fine in this case?
Well, the city, at respondent's own admission, when I explained this to him on my final inspection to give him the rental license, he admitted that he did collect in excess of $11,000 in rent from the tenant. So based on my conversations with my supervisors, that number was generated. Also, that it being a repeat violation and a handwritten note stating that he would not rent that property.
Also, may I interfere, Your Honor? She was ready to leave any day. She was telling me Venmo, Zelle, $100, $200. This whole thing was like trying to help her out.
Sir, did you collect rent from her?
Pardon?
Did you collect rent from her?
I did, but I'm telling you that I did it as a favor. I could break the lease, let's say.
All right.
But she never paid on time. She was ready.
This is what I'm going to do. Sir, in this case, it's pretty clear that you had a property that you rented without a license. I think that's indisputable at this stage. I will cut you a bit of a break. The city's asking for $100 a day. I'll reduce that to $50 per day. But in the future, you have to know, if you're going to have a property in the city of West Palm Beach and you're going to have somebody renting it, you have to have a license, you have to have a certificate of use. That's the rules, that's how they apply. And when you violate it, when you violate it the first time, the city gives you a break, which is they give you time to correct before they fine you. When you violate it a second time, the city comes after you pretty good. And in this case, you did violate it a second time. So, I mean, there's not much I can do here. I'm going to cut you a bit of break. I'm going to reduce their ask from 100 to 50. But it's still a substantial fine, and I hope in the future, no matter whether you're doing it for good reasons or bad reasons or whatever you're renting a property, just make sure you have a rental license. That's all.
Understood, Your Honor. Yeah. Anyway, it was special. Thanks for your cutting down, but I still feel...
I know, and I appreciate it. I think you...
I paid $15,000 to this court because I thought at one time there was car there. I cleaned everything. I
appreciate it, sir, but I've got to make the order.
I mean, just be as much fair you can be, at least at this point. I
reduced it in half, so that's about as fair as I can be.
The reason I brought up before, I was...
Ma'am, we're done. There's no more testimony. I just have to make the order.
He didn't rent it out, though, the first time. That's why I was confused.
All right, CE 260-55346, I make the following findings of fact and law. I find the respondent is in violation of 22441 and 2232, and that's a repeat violation of the code of the city of West Palm Beach. I hereby assess a fine of $250 for the failure to obtain a rental license and a fine of $50 a day for 280 days for the certificate of use. Thank you for coming in.
Thank you.
Okay, that's all we have for contested matters at this time. Next case, number 3, 1475 North Mangonia Circle, CE 26055-326.
Good morning. Kishana Watson Foster, Code Enforcement Officer with the City of West Palm Beach. 1475 North Magnolia Circle was referred to me by the Development Services Department for delinquent BTR. The property was cited for Section 22-441, rental license, being outstanding as of September 30th, 2025, and 22-32-A, certificate of use, being expired as of 9/30/2025. I initiate my investigation on May 8, 2026. The city issued a notice of violation, which identified the violations, include my contact information, and provide notice of today's hearing. The notice was mailed by both regular and certified mail on June 11, 2026 by the city clerk. The certified mail was received and signed for on June 13, 2026. In addition, the notice of violation was posted at the property and city hall on May 8, 2026, and I completed an affidavit of posting on that date, which is located in the case file. As of this morning, June 17th, business remained out of compliance as the outstanding fees are not paid. At this time, the city is respectfully requesting 15 days be granted for compliance. If not, a fine one time of $254, Section 22-441, and a daily fine of $100 for 22-32A.
Special Magistrate, the city would like to enter the case file, including the photos and testimony as evidence.
Is anyone here on behalf of the respondent? Seeing no one, without objection. So this is a rental license
Correct.
and a certificate of use?
Correct.
And how long did you want to keep them, to give them for compliance?
15 days.
I'm sorry?
15 days.
15 days?
Correct.
Why 15 days? We usually give them 30.
No, so for all the delinquent BTRs, which is just payment, because if you go online right now, make the payment, it closes the case, is this a payment that is required?
So this is just a failure to make the payment? Is that
Correct.
it? Okay. And you wanted $250 for the rental license?
So it's $250 for the, yes, and then the certificate of use.
And 15 days for the certificate of use? And what fine were you seeking?
So $250 for the rental license, and then the certificate of use, $100 per day.
All right, in case CE 26055-326, I'll make the following findings of fact and law. If I notice sufficient, I find the property in violation of 22441 and issue a one-time fine in the amount of $250. And violation of 2232, certificate of use. Respondent has 15 days or a fine of up to $100 per day may issue.
Number 4241 Plymouth Road, CE 26055-358.
Good morning. My name is Olivia Thomas, Code Enforcement Officer for the City of West Palm Beach. On May 12th, 2026, while on patrol on Plymouth Road, I observed an active construction site where multiple trees were not provided with the required protective barriers. This appeared to be a violation of Code 94-448-F-1, which requires that during land altering and construction activities, it's 241 Plymouth. Protective barriers. For the time being, I have a printed copy. Okay, which requires that during land altering and construction activities, protective barriers specified by the Planning and Zoning Administrator be erected and maintained around all trees or groups of trees to be protected. I issued a verbal warning to members of the construction team and advised that I would be returning with a notice of violation. I explained that the advance notice would allow time to install the necessary protection so the case could be brought into compliance on my next visit. I clearly stated both verbally and in the written notice that all trees on the property, including those in the backyard, must be protected. The backyard is openly visible from the main road. Photographs were taken during the inspection and accurately depict the observed violations. On May 18th, 2026, I posted the notice of violation at the property. The notice included my contact information, details regarding this scheduled hearing, and contact information for the city's arborist for assistance with tree protection requirements. I also completed an affidavit of posting on the same day. During the visit, I noticed that partial compliance had been achieved. However, only one tree, the tree in the front yard, had been properly protected. The notice was additionally delivered via certified mail on June 2nd, 2026. No contact was received from the owner or any representative prior to June 15th. The most recent inspection photographs were taken on June 15th, 2026, and showed the property remained out of compliance. On June 15th, I used the city's database to locate the phone number associated with the active water account to determine if anyone would be present at today's hearing. The account holder was listed as Ian Zinn, one of the property owners. I left a voicemail. On June 16th, I received a voicemail from Mr. Zinn stating that his contractor manages the property and he thought the property had been in compliance for weeks. He said he wouldn't be at the hearing today because he's traveling. Mr. McDonald contacted me by phone requesting clarification on which trees needed protection. I informed him that all of the trees on the site needed protection. The city recommends allowing an additional 14 days for the property to achieve full compliance. If compliance is not achieved by June 30th, 2026, the city recommends imposing a daily fine of $50.
Thank you. Special Magistrate, the city would like to enter the case file, including the photos and testimony into evidence.
Without objection, so admitted. So in your pictures, the ones that have the little mesh.
Mm-hmm. Oh yes, that's just the one in the front yard, which is in compliance.
That one is in compliance.
Yes.
So how many trees are out of compliance?
If you see in the pictures, they're in the backyard, like this one, that's one of the trees in the backyard, and next to it is a row of approximately, I'd say about maybe 5 to 10 trees, which have no protection. So that's like on the main front yard, this one up on the screen. And then you can see that there's just like a cluster of trees in this particular picture that's up on the screen. I'm not able to identify how far it goes back. I know that the construction site goes all the way into the back further into the property, but I haven't entered the property to see, but based on what I can view, none of them have protection.
14 days is enough time to put up protection on all these trees?
Yes, it's very simple. They just have to put stakes in the ground. Some people have even just wrapped it in that mesh. It's something that could maybe even take less than an hour. If they just wanted to wrap something, and I usually get Tiffany Kapner and Megan's approval just to make sure. It's kind of visual as well to make sure that they don't back into anything or back into any of the trees and damage them. Just to make sure that they can see what kind of clearance they have not to damage the trees.
I'll trust your expertise on that. In case CE 260555358, I make the following findings of fact and law. I find properties in violation of 94448F1, tree protection required. Respondent has 14 days to come into compliance, or a fine of up to $50 per day may issue.
Thank you.
Number 10, 725 56th Street, CE 26045265.
Good morning. My name is Alessio Carulli, Code Enforcement Officer for the City of West Palm Beach. Property at 725 56th Street was observed to have the following violations, which are still in non-compliance. The 94-442-2, which is the landscaping, squares, and parkways, was observed, that the squares and parkways were missing sod or approved plant material. 94-482-A, which is parking requirements. It was observed that there is a vehicle that is parking on the grass and it needs to be on a non-dusting surface. So the city issued a notice of violation to the property owner, which identified the violations, contact information, and notice of today's hearing. The notice of violation and notice of hearing were sent via certified and regular mail on 5/6 of 26 and received and signed on 5/18 of 26. The notice of violation was issued at the property on 4/30 of 26, and violation, an affidavit of posting dated 5/1/26 is in the case files. Photos were taken at the initial investigation, and when the property was revisited, these photos accurately and truthfully depict the violations observed during the investigation. I have had no contact with the owner. The city is requesting 30 days or a $100 fine per day until compliance is achieved, and the city does believe that this time requested is more than enough time for the owner to achieve compliance.
Thank you, sir. Special Magistrate, the city would like to enter the case file, including the photos and testimony into evidence.
Is anyone here on behalf of the respondent? Seeing no one without objection, so admitted. So basically, we need ground cover and that car moved.
Correct. Yes, sir.
All right, in case CE 260455265, I make the following findings of fact and law. I notice is sufficient to find the property in violation of 94442E and 94482A, specifically the ground cover. The property needs landscaping or ground cover, and the car cannot be parked on the grass. Respondent has 30 days to come into compliance, or fine of $100 per day may issue.
Number 13361 Westminster Place, CE 25073916.
Good morning. Officer Raphael Forrester, Code Enforcement Officer for the City of West Palm Beach. The property was cited on 7/21/25, which was revised in 5/11/26, and posted on the property 5/12/26. Service was accomplished by certified mail and regular mail on 10/9/26. I had been in contact with the owner of the property. The property was cited for the following violations: 94442E, landscape, swell, and parkways. I observed that the parkway still is in need of grass. 94442C1, landscape areas must be grass. I observed areas along the front of the property that needs grass, sod, or approved plant material due to not being maintained. 10106K, landscape maintenance. I observed that the landscape on the property is not being maintained in accordance with the city code requirements. 10106A, clean and sanitary. I observed that there is black residue throughout the walkway, also with the trash and debris throughout the property. All photos accurately and truthfully depict the violation when observed. As of June 12, 2026, the property has not come into compliance. Therefore, the city is requesting an additional 45 days to achieve compliance. I believe 45 days is enough to correct the violation. If they don't come in compliance, the city is asking for $100 a day until compliance is achieved.
Thank you, sir. Special Magistrate, the city would like to answer the case file, including photos and testimony and its evidence. Is anyone here on behalf of the violator? Without objection, so admitted. You have a lot more code sections listed here. Are you just pursuing the four that you mentioned?
These are the ones that are in violation right now. The other ones are complied.
94442E for the missing grass, 94442C1 for the missing grass in the front, and 18106K for the non-maintained landscaping. And what was the other one?
The clean and sanitary for the walkway, and for the trash and debris throughout the property.
18106A. Is that correct?
Yes.
Yeah. Have you had any contact with the respondent at all?
I did in the beginning of the case, and then when I actually posted again for the revision, she attempted to call me, left message, call back, so like phone tag on the with the case. So.
And you believe that 45 days is a sufficient amount of time to bring this into compliance?
Yes.
All right, case CE250739116, I make the following findings of fact and law. If I notice is sufficient, I find that the property in violation of the listed code sections I adopt by reference to testimony of the code officers. The nature of those violations, I give the respondent 45 days to come into compliance, or a fine of $100 per day may issue.
Number 14725 45th Street, CE26045223.
Good morning. Officer Raphael Forster, Code Enforcement Officer for the City of West Palm Beach. This property was cited on 4/21/26 and posted on the property 4/22/26. Service was accomplished by certified mail and regular mail on 5/15/26. I have been in contact with the owner of the property. This property was cited for several violations. 7894C, swale parkways need sod and grass. I observed the areas in the parkway missing grass. Although the sod was laid down, the sod was dying and due to lack of water. 94302A4, fence repair. I observed a wooden fence in disrepair. 18106B, 18106K, overgrowth property, excessive growth. I observed areas throughout the property and landscape with excessive growth of weeds and grass. 18106J, painting the exterior. I observed peeling paint, faded areas, and bare wood exposed throughout the structure. 94442E, landscape in the parkway. Observed the parkway still in need of sod and grass. The sod of the grass was laid, not maintained. Looks like it didn't water it. And 94442C1, landscape areas must be grass. I observed areas along the front of property that needs grass out of approved plant material due to not being maintained. 18106, clean sanitary trash and debris. I observed trash and debris throughout the parkway. All photos accurately and truthfully depict the violation when observed. As of June 10th, 2026, the property has not come into compliance. Therefore, the city is requesting an additional 45 days to achieve compliance. I believe 45 days is enough time to correct the violations. If they do not come into compliance, the city is asking for $100 a day until compliance is achieved.
Thank you, sir. Special Magistrate City would like to enter the case file, including the photos and testimony into evidence.
Is anyone here on behalf of the respondent? Seeing no one without objection, so admitted. Have you had any contact with this one?
At the initial time, I met the owner out there, explained everything that needed to be done. Haven't heard from him since.
Did they lay that grass in
They
response?
laid the grass down, but they did nothing. They didn't water or nothing. So we're right back to square one.
All right, KCE 260452223, I make the following findings of fact and law. If I notice is sufficient to find the property in violation under the code sections listed, I adopt by reference testimony of the code officers to the nature of those violations. I give the respondent 45 days to come into compliance or a fine of $100 per day may issue.
Number 154207 South Olive Avenue, CE 26055-317.
Good morning, Officer Raphael Forrester, Code Enforcement Officer for the City of West Palm Beach. This property was cited on 4/7/26, posted on property 4/8/26. Service was accomplished by certified mail and regular mail on 5/15/26. I have not been in contact with the owner of the property. The property was cited for several violations, 94442E, landscape swells and parkway. I observed the parkway still in need of grass. 94442C1, landscape areas must be grass. I observed areas along the front of the property that needs grass out or approved plant material. 24441, rental license, business tax receipt. I observed that this property is renting without a business tax receipt, and section 2232 certificate of use is required, and I observed in our system that the property is in need of a certificate of use. All photos accurately and truthfully depict the violation when I observed. So as of June 15th, 2026, the property has not come into compliance. Therefore, the city is requesting an additional 30 days to achieve compliance. If they don't come in compliance, the city is asking for $100 a day until compliance is achieved for the violations of 94442E and 94442C. The city is also asking for 30 days and a $200 fine for the violation of 22441 rental license, and a $200 a day for the certificate of use until compliance is achieved. And I believe 30 days is enough time to correct the violation.
Thank you, sir. Special Magistrate City would like to enter the case file, including the photos and testimony into evidence.
Is anyone here on behalf of the respondent? Seeing no one without objection, so admitted. All right, walk me through your request again. So which code sections and what were you asking for?
For the rental?
Just walk me through the whole thing again, because I
Okay.
lost track of where you were.
Okay, so in 30 days, and $100 a day for the 94442E and 94442C.
So that's for the landscape and the swale.
Correct.
Okay.
And 30 days for a $250 fine for the 22441, and then $200 for the certificate of use until compliance is achieved.
All right. KCE 26055-317, I make the following findings of fact and law. I notice is sufficient to find the property in violation of 94442E and 94442C1. I adopt by reference the testimony of the code officers, the nature of those violations, including the missing grass. I give the respondent 30 days to come into compliance or $100 per day for those violations. As to, I find the property in violation of 2232 for the absence of certificate of use, and 22441 rental license BTR. I issue a one-time fine in the amount of $250 and 30 days to come into compliance or fine of $100 per day.
Number 161464 7th Street, CE 26055-370.
This really is rental license day, huh?
Good morning, Code Officer Kay Weaver with the City of West Palm Beach. While completing business tax assignment in my zone, I discovered violations at 1464 7th Street. I uploaded a photo of the violation of the screenshot of them having no license, which accurately and truthfully depict the violations observed. I initiated my investigation on May the 15th of 2026, citing multiple violations. The remaining violations are 22-441, rental license, or no rental license, 22-32, no certificate of use. The notice of violation was posted at the property and City Hall on May the 18th of 2026. Certified and regular mail was sent on June the 8th of 2026 to the mailing address listed on property appraisers. Certified mail was signed for on June the 17th of 2026. I observe the rental license and COU still in violation of the previously listed violations, meaning it has not been complied. I received an email from Main Street Renewal about the violations, and they stated they had paid for the license, but as of 2024, payments were made, but no inspection has been completed. So the city is requesting a one-time fine of $250 for the 22-441 rental license and an additional 30 days or $100 a day for 22-32 certificate of use until compliance is achieved.
Did you tell them they didn't do their inspection?
Yes, and this has been ongoing for a while, yes.
All right, KCE 260, well, I guess you want to put the...
Yeah, thank you, sir. City would like to enter the case file, including the photos and testimony as evidence.
So admitted. In case CE 260-55370, I make the following finding of fact and law. If I notice is sufficient, find the property in violation of 22441, the rental license, I issue a one-time fine of $250 for that. And section 2232, certificate of use, which I give them 30 days to come into compliance, or a fine of up to $100 per day, issue.
Number 17721 North Australian Avenue, CE 260-55272.
Code Officer Kay Weaver again with the City of West Palm Beach. I received a complaint for the property at 721 North Australian Avenue. I observed multiple violations at the property. I took photos of the violations, which accurately and truthfully depict the violations observed. I initiated my investigation on April the 29th of 2026, citing multiple violations. The remaining violations are 78-94 Swellsden Parkway. What's remaining there is removing, he has like some little concrete domes of curbstones, and also maintenance in the Swellsden Parkway. 18-106-B, overgrowth, cutting, edging, and trimming. 94-71-C, outdoor storage. Multiple things, crates, bins, excessive ceramics, etc. 94-446-2-E, edging around the entire property. 74-4-C-4, trees or hedges obstructing the right-of-way. This will be on the Australian side of the property. 18-106-A, clean and sanitary, removing all trash and debris from property and pressure washing sidewalks. 34-102, inoperative, junk or unregistered vehicle needs to be removed. It has been moved. I did have additional, but it has been moved from the grass and now it's in the driveway. The notice of violation was posted at the property and City Hall on May the 4th of 2026. The affidavit of posting was completed on May the 4th of 2026 and a copy placed in the case file. Certified and regular mail was sent on June the 10th, 2026 to the mailing address listed on property appraisers. Certified mail was signed for. I revisited the property on June the 15th of 2026 and observed the property still in violation of all the violations previously listed. Reinspection photos were taken showing the remaining violations. They were uploaded to the case file. I've had contact with a Mr. Victor Norfus. He stated that he was the owner's nephew. He came into City Hall on June the 12th. He inquired about the violations and also informed me of his progress of what he had been working on at the property. The city is requesting an additional 60 days or $100 a day until compliance is achieved.
Thank you, ma'am. Special Magistrate of the city would like to enter the case file, including the photos and testimony into evidence.
Without objection, so admitted. The inoperable vehicle, is that because the registration's expired?
Yes, he claims it runs, but I don't know, but I know it's not registered. He did state that he didn't have a registration, but he was going to move it into the garage, but that has not happened as of yet.
Okay. All right, in case CE 260-55272, I make the following findings of fact and law. I find notice is sufficient. Find the property in violation of the code sections listed by the code officer, and I adopt by reference the testimony of the code officer as to the nature of those violations. Give the respondent 60 days to come into compliance, or a fine of up to $100 per day may issue.
Number 18801 North Australian Avenue, CE 260-55273.
Code Officer K. Weaver again with the City of West Palm Beach. While checking a complaint in my zone, I observed violations at 801 North Australian Avenue. I took photos of the violations, which accurately and truthfully depict the violations observed. I initiated my investigation on April the 29th of 2026, citing multiple violations. The remaining violations are 18-106-M, landscape maintenance, cutting, trimming, edging, watering, and maintaining. 78-94, swells and parkways, replace sod in the bare dead areas of the yard and swell and keeping trash out. 74-34-A-1-H, trash can in public view. 94-446-2-E, edging around the entire property. 18-106-B, overgrowth, cutting, trimming, edging the property and swell area. 18-106A, clean and sanitary, removing trash and debris and pressure washing the sidewalks. The sidewalks only on the Australian side. The notice of violation was posted at the property and City Hall on May the 4th of 2026. Certified and regular mail was sent on May the 27th of 2026 to the mailing address listed on property appraisers. Certified mail was signed for. The property was revisited on June the 17th and observed the property still in violation of the previously listed violations. I was contacted and I spoke to a Madeline Guzman multiple times about the violations and how to comply them. Some efforts have been made, but not completed. The city is requesting an additional 60 days or $100 a day until compliance is achieved.
Thank you, ma'am. Special Magistrate of the city would like to enter the case file, including the photos and testimony into evidence.
Without objection, so admitted. So you're not pursuing the paint?
They painted the areas on the house. That was one of the things that were done, yes. Only what I named is only things remaining.
And you believe 60 days is a sufficient amount of time?
Yes, sir.
All right, in case CE 260-55273, I make the following findings of fact and law. If I notice is sufficient, I find the property in violation of the listed code sections. I adopt by reference to testimony of the code officer as to the nature of those violations. I give the respondent 60 days to come into compliance, or a fine of $100 per day may issue.
Thank you.
Number 19, 8007 Arlington Place, CE 2603572.
A case with only one code section.
You're welcome. Good morning. Joseph Berna, Code Enforcement Officer, City of West Palm Beach. On March 18th, 2026, while on patrol, my attention was called to the property at 8007 Arlington Place. Numerous violations were observed and documented. Since the time of the notice of violation being posted on the property, I've been in constant contact with the property owner, Mr. Francisco Pedron, and his tenant, Mr. Daniel Cleary. The notice of violation was posted on the property March 19th, 2026. Certified regular mail were sent on May 13th, 2026. Certified mail was received and signed for on May 28th, 2026. Affidavit of posting was completed on March 19th, 2026, and is in the case file. On June 16th, I returned to the property for a final inspection before today's hearing and found the property not in compliance, photographing the unresolved violations. The following violation is still not in compliance. Section 94-485-E, servicing of parking and loading It's gravel driveway. All photographs taken during the course of this investigation accurately and truthfully depict my observations. Mr. Padron and his tenant have been plagued with health issues which have slowed down the compliance process. Now that all violations, a part of the driveway, have been resolved, he is now in the process of securing the services of a licensed contractor who will then obtain the necessary permits and bring the driveway into compliance. Therefore, the city requests 180 days be granted for compliance to be achieved, or the property owner be subject to a fine of $100 per day thereafter until compliance is achieved. The city feels an additional 180 days is reasonable given the nature of the unresolved violation and is more than enough time for the property owner to obtain the necessary permits and complete the project.
Thank you, sir. Special Magistrate, the city would like to enter the case file, including the photos and testimony into evidence.
Without objection, so admitted. That's a gravel driveway, huh?
Yeah, and fortunately, there's asphalt underneath it. So he's going to have
Does
it
somebody
all.
just put gravel on top of it? I guess probably the asphalt was
I
cracking or
found that hard to believe myself.
Yeah, well, I guess the logical reason somebody might do that is if the driveway's in disrepair, they just cover it with gravel, and that way it doesn't look so bad, right? I don't know. Either way, you can't do that in the city of West Palm Beach, so I think it doesn't really matter why they did it, I suppose. All right, in case CE 260387072, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 94485E. Specifically, the driveway has to be a non-dusting surface. Respondent has 180 days to bring the property into compliance or a fine of $100 per day may issue.
Number 27604 Martin Avenue, CE 2603562.
Joseph LaPerna, Code Enforcement Officer, City of West Palm Beach. On March 13th, 2026, the Code Enforcement Department received an email complaint regarding the property located at 7604 Martin Avenue. The complaint was regarding the rear of the property fencing facing South Olive Avenue. On March 18th, 2026, I was assigned to investigate the complaint and responded to the property. While there, not only did I confirm the conditions of the fence described in the complaint, but several other violations were observed and noted. Contact was made with the owners of the property regarding the violations. I learned the property is a rental and all licenses for said rental are current. The notice of violation was posted on the property and at City Hall on March 18th, 2026. Certified and regular mail were sent on May 14th, 2026. Certified mail was returned on June 10th, 2026. The affidavit of posting was completed and filed on March 18th, 2026, and is in the case file. On June 15th, 2026, I returned to the property for a final inspection before today's hearing and found the property not in compliance, photographing the unresolved violations. The following violations are still not in compliance as of June 15th. Section 94-442-C-1, grass or sod or approved landscape material to be placed in open landscape areas. Section 94-302-A-4, fence to be repaired or replaced in a workmanlike fashion. Section 94-446-E, edged the walkways of landscape growth. And Section 18-106-B for excessive growth. All photographs I took accurately and truthfully depict violations and corrections I observed during the course of my investigation. The owners contacted a contractor for a new fence after an attempt to fix the fence failed a follow-up inspection on May 11th. A permit for a new fence has been applied for on June 11th and is awaiting approval. As far as the other violations, the owner continually states that items have been resolved, but when I returned to the property for an inspection, I found it was not the case. Therefore, after speaking with the owners, the city's requesting an additional 90 days be granted to achieve this compliance. If compliance has not been achieved in 90 days, we request the property owner be subject to a fine of $150 per day thereafter until compliance is achieved. The city believes this is more than enough time to achieve compliance.
Thank you, sir. Special Magistrate, the city would like to enter the case file, including the photos and testimony into evidence.
Without objection, so admitted. Why do they think they keep complying?
I don't know. If they the pictures of the fence are what baffles me, is that they took 6-foot planks and nailed them to the defective 4-foot planks.
Fascinating.
They thought that was suitable, and I explained to them otherwise.
They thought that was good, huh?
They thought that was good. So they did apply for the permit, and I told them they have 90 days.
All right, case CE 260-35062. I make the following findings of fact and law. If I notice is sufficient, I find the property in violation of the listed code section cited out by reference testimony of the code officer's nature of those violations. Respondent has 90 days to come to compliance, or a fine of $150 per day may issue.
Number 21, 215 Elaine Circle West, CE 260-35126.
Joseph Laperna, Code Enforcement Officer, City of West Palm Beach. On March 26, 2026, while on patrol, my attention was called to the property at 215 Elaine Circle West. Numerous violations were observed and documented. On April 30th, 2026, while doing a follow-up inspection, a female exited the residence asking what my problem was. She identified herself as the property owner's mother. I briefly explained to her the violations in question. She responded, it's her son's house, and she didn't know anything about that, and she went back into the house. Since then, I've had no other contact with the owner or occupants. The notice of violation was posted on the property and at the West Palm Beach City Hall, March 27th, 2026. Certified regular mail sent on May 13th, 2026. Certified mail was returned on June 11th, 2026, and the affidavit of posting was completed on March 27th, 2026, and is in the case file. On June 15th, I returned to the property for a final inspection before today's hearing and found the property not in compliance, photographing the unresolved violations. The following violations are still not in compliance as of June 15th. Section 94-442-E, grass, sod, or approved landscape material to be placed in swale or parkway. 94-71-C, outdoor storage. 94-482-A, unpaved parking of vehicles. 18-106A, trash and debris. Section 78-1 is continual, but parking vehicles obstructing the sidewalk right-of-way, and it is an ongoing issue according to neighbors. 18-106B, excessive growth on the property. 86-226, prohibited parking in the swale or parkway. All photographs taken during the course of the investigation accurately and truthfully depict my observations. There has been little to no compliance aside of a prohibited trailer being removed. Therefore, the city requests 30 days be granted for compliance to be achieved, or the property owner be subject to a fine of $200 per day thereafter until compliance is achieved. The city feels an additional 30 days is reasonable given the nature of the unresolved violations, and is more than enough time for the property to be brought into compliance.
Thank you, sir. Special Magistrate of the City would like to enter the case file, including photos and testimony and evidence.
Without objection, so admitted. The 9442A, the parking requirements, what is that?
94, which one?
The first one, 9442A.
Oh, unpaved parking of vehicles. So what they're doing is the initial, when I go there, there's always a truck parked on the, you'll see it in the initial pictures. There's a truck parked on the grass, keeps driving over the swale, that one right there on the right. And then what they're doing is they have people coming in during the day, and because there's so much stuff in the driveway, they're parking partially on the driveway, in the swale, and blocking the sidewalk as of 2 days ago, too.
So that's your obstruction of the sidewalk? Okay. The landscaping issue, is that just the ground that was disturbed by the cars?
Yes, for the placement of sod, correct. And then there's overgrowth everywhere where there's garbage.
Parking in the swales. What's the outdoor storage? Oh, okay, I see. All right. Got that one. And clean and sanitary, I guess, is also the debris around there as well.
That as well, and then I explained to the lady that the power washing of the driveway,
And what's the overgrowth?
All over, where there's trash and debris, they don't cut around it, so there's excessive growth around the property.
And you believe 30 days is a sufficient amount of time to bring this into compliance?
Absolutely.
All right, case CE 26035-126, I make the following finding of fact and law. If I notice is sufficient, I find the property in violation of the listed code sections. I adopt by reference testimony of the code officers the nature of those violations. Give the respondent 30 days to come to compliance or a fine of up to $200 per day may issue.
Number 22, 411 Oxford Street, CE 26035-043.
Joseph Laperna, Code Enforcement Officer, City of West Palm Beach. On March 12th, 2026, I was assigned to investigate a complaint for property violations at 411 Oxford Street in West Palm Beach. On March 16th, I responded to the property and discovered several violations which were noted. Contact was made with the owners of the property regarding the violations. They stated they purchased the property in March of 2025 with long-term plan of building a house there. Notice of violation was hand-delivered and signed for by co-owner Tamara Rowe on March 16th, 2026. Certified and regular mail were sent May 14th, 2026. Certified mail was received and signed for May 26th, 2026. Affidavit of posting was completed and filed March 16th, 2026, and is in the case file. On June 15th, 2026, I returned to the property for final inspection before today's hearing. Found property not in compliance, photographing the unresolved violations. Following violations are still not in compliance as of the 15th of June. Section 94-442-C-1, grass, solder, approved landscape material to be placed in open landscape area. Section 94-442E, grass or sod in the swale area, swale or parkway. All photographs I took accurately, truthfully depict violations and corrections I observed during the course of my investigation. The owners have started the permit process for the construction. A permit was applied for on June 11th, 2026 for new construction of a single-family dwelling. Meanwhile, the owner has blocked all access to the property to prohibit vehicles from parking there. Preface this, the owners own the business at the corner of Oxford and South Dixie. So what he did was he ripped out all of the landscaping and he put gravel down in the, on the lot and in the swale for parking for employees and customers. So that was, those were the violations initially that I documented. Since then, like I said, he gated it and he put cones up to restrict or to
prevent the parking.
Prevent people from parking in the swale. Therefore, after speaking with the owners regularly, the city is requesting an additional 180 days be granted to achieve compliance. If compliance has not been achieved in 180 days, we request he be subject to a fine of $150 per day thereafter until compliance is achieved. The city believes this is more than enough time to achieve compliance.
Thank you, sir. Special Magistrate, the city would like to enter the case file, including the photos and testimony and evidence.
Without objection, so admitted. So that in the city's view, compliance is either resodding it or building something there.
Correct. He does have the permit. The electrical has already been put in the back for service for the construction. He applied for a building permit to build a single-family dwelling there. And the reason the 180 days, if the permits are approved with the site plan
then he would be in
and the
compliance.
landscaping plan, then that'll cover, if they're parking in the swale, but that'll cover the landscaping in the swale and on the lot.
That sounds reasonable to me. Case CE 26035-043, I make the following findings of fact and law. If I notice sufficient, I find the property in violation 94-442E and 94-442C1. The landscaped areas have to be properly surfaced. Respondent has 180 days to come to compliance or fine of $150 per day measure.
Number 23, 401 North Rosemary Avenue, Trusted Paralegal Services, CE 2604-5252.
Good morning. Don Williams, Code Enforcement, City of West Palm. Business Trusted Paralegal Services, LLC, was cited on April 29th of 26 for business tax receipt, City Code 82-144. Previous business tax receipt expired September 30th of 2024. Certified regular mail mailed out on May 14th of 26. Property posted 4/30 of 26. No contact with the business owner. However, the business manager of Cityside Suites, Josie Studstill, verified that the business still operates from that location. My recommendation today will be 15 days to comply or a one-time fine of $250.
Thank you, sir. Special Magistrate of the city would like to enter the case file, including the photos and testimony as evidence.
Without objection, so admitted. So all they really have to do here is pay?
That's it.
I guess I can reason that 15 days is probably sufficient time to do that.
Yes.
All right, in CE 26045-252, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 82144, which is they need a business tax relief for their business. If the respondent has 15 days to come to compliance, or a fine of $250.
Number 24, 401 North Rosemary Avenue, Worldwide Community Alliance, CE 26045-249.
Don Williams, Code Enforcement, Worldwide Community Allowance, business located at 401 North Rosemary Avenue, was cited by me on April 29th of 26 for a business tax receipt, City Code 82-144. Previous business tax receipt expired September 30th of 25. Certified regular mail mailed out May 14th of 26. The property itself posted 4/30 of 26. No contact with the business owner. However, the manager of Cityside Suites, Ms. Josie Studstill, verified that the business does operate from that location. So my recommendation today is 15 days to comply or a one-time fine of $250.
Thank you, sir. Special Magistrate of the city would like to enter the case file, including photos and testimony as evidence.
Without objection, so admitted. Is this a different business than the previous
It is.
case?
It's a Cityside Suites.
Was the previous case not Cityside Suites?
Yes, that's the building itself, Cityside Suites, but I have several businesses located within the suites.
Oh, I thought Sweets was like a candy store. You mean Sweets like, okay, so
Yeah.
that's the owner of the building.
Yeah.
Okay, all right. Maybe I'm just hungry. All right, in case CE 26045-249, what is the business here, by the way?
The name of the business?
Yeah, the actual business that's operating here, what is it?
Oh, that's Worldwide Community Allowance.
Respondent is in violation of 82144B2R, which is their business tax receipt. They have 15 days to come to compliance or a $250 fine.
Number 25, 401 North Rosemary Avenue, Florida Best Elite Services, CE 26045-2453.
Don Williams, Code Enforcement, business Florida Best Elite Services, located at 401 North Rosemary Avenue, was cited by me for a business tax receipt on April 29th of 26, City Code 82-144. The previous business tax receipts expired September 30th of 25. Certified mail, regular mail, sent out 5/14 of 26. Property posted 4/30 of 26. Contact was made with the business owner, Mr. Anthony Bradford, who indicated he would actually pay that fee for the license, which he has not done as of yesterday. Also, the business manager did verify that he still operates from that location. So my recommendation again is 15 days or a one-time fine of $250.
Thank you, sir. Special Magistrate of the city would like to enter the case file, including the photos and testimony as evidence.
Without objection, so admitted. In case CE 26045-253, I make the following findings of fact and law. I find notice sufficient from the property in violation of 82144 BTR. Give the respondent 15 days to get their business tax receipt or a fine of $250.
Number 26, 723 21st Street, CE 26055-332.
Don Williams, Code Enforcement, City of West Palm. The property at 723 21st Street was cited on May 11th of 26 for the following code violations: 22-441, rental license, 22-32A, certificate of use. Additional to that, the following violation was observed once I visited the property: 78-6, which the address character is missing; 18-106A, clean and unsanitary condition; 18-106B, overgrowth. Certified and regular mail was actually mailed out May 14th of 26. The property itself was posted 5/12 of 26. Contact has been made with the property owner. The only remaining violations that's not complied are the rental license and certificate of use. She actually applied on May 12th or 26th, but we're just really waiting on zoning to approve the application itself. So my recommendations, 30 days to comply or a one-time fine, 30 days to comply or a one-time fine of $250 for the business tax and a $200 per day fine for the certificate of use.
Thank you, sir. Special Magistrate of the city would like to enter the case file, including photos and testimony and evidence.
Without objection, so admitted. So Officer Williams, they've dealt with the numbers, the clean and sanitary, and the overgrowth?
Yes.
All right. And they've applied for the rental license?
They did, yes.
Okay. All right, in case CE 260553332, I make the following findings of fact and law. If I notice sufficient to find the property in violation of 22441 rental license, I give the respondent 30 days to bring that into compliance or a one-time fine of $250. And I find the respondent in violation of 2232 certificate of use, give them 30 days to comply for that or a $200 per day fine.
Number 27, 809 2nd Street, CE 260554332.
Don Williams, Code Enforcement, City of West Palm Beach, 809 2nd Street, was cited on 528 or 26 for the following city code, 74-4-A, which is trash and debris. Illegal dumping was actually in the alleyway, illegal dumping. Certified and regular mail was mailed out June 11th of 26. The property itself was posted May 28th of 26. Contact has been made with the property owner. They made several attempts to comply this week, but failed to actually complete the process completely. So today I'm asking for additional 5 days or $50 per day for a fine. I emailed and spoke with her this morning, so she's aware that additional removal of trash in the alleyway.
Thank you, sir. Special Magistrate of the city would like to enter the case file, including the photos and testimony and evidence.
Without objection, so admitted. So this is just the trash in the alleyway behind the house?
Yes.
Let's give them 10 days just because of the way that mail works around here.
Okay.
In case CE 260554432, I make the following findings of fact and law. I find notice sufficient to find the property in violation of 744A, specifically the trash dumped behind the house in the alleyway. Respondent has 10 days to come into compliance or a fine of up to, what fine were you seeking?
I'm sorry?
What fine amount were you seeking?
$50 per day, 50.
Or a fine of up to $50 per day, Mish.
Number 28, 632 13th Street, CE 2605582.
Don Williams, Code Enforcement, 632 13th Street, was cited on May 4th of 26 for the following code violations, which I observed. 18-103J, exterior paint. 94-302-A-4, fence repair. 18-106L, need landscaping. 94-71C, outdoor storage. 78-6, address characters. 18-106B, overgrowth. 78-1, obstruction of right-of-way. 18-106A, trash and debris. The following two violations are complied. Address characters can now be seen from the roadway, and the obstruction of the roadway, which is cut back some trees. Regular mail, certified mail was sent out May 14th of 26. Property itself posted May 7th of 26. No contact with the property owner, contact only with the tenant. And so my recommendation today will be asking for 30 days to comply or a fine of $100 per day thereafter.
Thank you, sir. Special Magistrate of the city would like to enter the case file, including the photos and testimony and evidence.
Without objection, so admitted. So the obstruction of the right-of-way is good?
Yes, just a tree that was cut, so you can see the
And the address
character.
numbers are good now?
Yes.
But everything else is still outstanding?
Yes.
And you see any effort to actually bring those into compliance?
No.
And you believe 30 days is a sufficient amount of time?
Yes. Just a cleanup.
I can see the fence. What's the paint issue? Is it the house?
No, the walls in the front, you'll see that missing paint. Well, that's one portion of the wall. But
I can definitely see the landscaping issue.
There you go.
I can see the outdoor storage issue. The overgrowth, what's that?
Still in the rear. You see the overgrown grass. That's the paint on the walls there.
Yeah.
There's some wild stuff in the back.
Oh, okay.
There you go.
Yep, good.
There you go.
And trash, okay. KCE 260555282, and make the following findings of fact and law. I find notice is sufficient to find the property in violation of listed code sections. I adopt by reference testimony of the code officer as the nature of those violations. Respondent has 30 days to come to compliance, or a fine of $100 per day may issue.
Number 29, 401 North Rosemary Avenue, CE 260452447.
Don Williams, Code Enforcement, business located at 401 North Rosemary Avenue. The National Pan-Atlantic Council of Palm Beach County was cited on April 29th of 26 for a business tax receipt on the City Code 82-144. The previous license they had expired September 30th of 25. Certified regular mail sent out May 14th of 26. Property itself posted 4/30 of 26. Contact was made with the president of the council. However, no business tax payment has been made. Also, the business manager, Ms. Studstill from Cityside Suites, did verify the business still operate from that location. Recommendation today is a one-time, 15 days to comply, or one-time fine of $250.
Thank you, sir. Special Magistrate of the City would like to enter the case file, including photos and testimony into evidence.
Without objection, so admitted. In case CE 260452447, make the following findings of fact and law. I find notice sufficient to find the property in violation of 82144 BTR. Respondent, and they don't have a certificate of use either, right?
No, no
All right.
certificate of use.
2232, respondent has 15 days to come to compliance or fine, one-time fine of $250.
Thank you very much.
And that completes the first part of the agenda.
So we're just to other matters, right? We had 11:30 on other matters? All right, so we're going to adjourn till 11:30. All right, I call us back into order. This is the schedule for other matters in the City of West Palm Beach code enforcement hearings. Cases will be called in the order in which they appear on the agenda unless otherwise noted. When you hear your case called, go ahead and proceed to the podium on my right side. The city will introduce the case, and then you'll have the opportunity to ask me for whatever it is that you're going to ask me. Most of the time, these are fine reductions. So if you're going to ask me for a fine reduction, please tell me exactly what you're asking me for and give me the reasons or justifications, hopefully ones that are in the code for that reduction, after which time I will make a decision. This is a quasi-judicial hearing, which means the formal rules of evidence do not apply here. However, all testimony is taken under oath under penalty of perjury. So if you're going to testify today, or you think you might testify, or there's a possibility that you might testify, I'd ask that you rise and raise your right hand so you can be sworn in. Anyone that's going to testify? Do you swear or affirm the testimony you're about to give will be truthful and accurate under penalty of perjury under the laws of the state of Florida? Yes.
Number 3258 Bloomfield Drive, CE 18010400.
Good morning, Code Officer Donald Lattimore, City of West Palm Beach. Lien KCE 180104000 was cited for unpaved parking, junk vehicle, rotten wood, dirty driveway, sidewalk, walkway, porch, and for fence repair. The order date was March 7th of 2018 with a comply by date of April 9th of 2018. The fine started to run on April 10th of 2018 at $100 per day. The property was brought into compliance on November 19th of 2018, in which the fine ran for 224 days for a total of $22,400. The city reached an agreement with the property representative, Ms. Elaine O'Malley, for $3,500 payable within 60 days.
Ma'am, can you state your name, please?
Sure. Eileen O'Malley, personal representative for the estate of Kevin King.
Ms. O'Malley, the city is representing that you've reached an agreement to reduce the fine to $3,500. Is that your understanding as well?
Yes, sir.
Did you have a date?
Payable within 60 days.
60 days?
Yep.
Does 60 days work for you?
That's fine. Thank you.
All right. In case CE 180104000, I reduce the fine to $3,500 payable within 60 days. If it is not paid within that time, it does return to the original amount.
Okay, thank you.
Here's a copy of your order behind you.
We are nothing if not efficient here.
Number 31, 1463 8th Street, CE 16080352.
Richard Pazmino, City of West Palm Beach Code Enforcement Supervisor. The property at 1463 8th Street has a lien code enforcement case. Case number CE 16080352. Case was cited for junk and/or inoperative vehicle, rotten wood, exterior paint, overgrowth, and address characters. The case was ordered on November 2nd, 2016, ordered to comply on December 2nd, 2016. On December 5th, 2016, the fine started running at $100 a day. The property came into compliance on April 11th, 2018, and was out of compliance for a total of 492 days. The current fine in this case is $49,200. I spoke to the applicant, Mr. Eric. I don't have his. Sorry.
English.
Yeah, Eric English yesterday, and his family, who are in charge of the estate, and came to an agreement to reduce the fine to $7,380, payable within 60 days. He was unable to attend, so he sent authorization to allow his cousin, I believe, Mr. Timothy, to attend.
Sir, can you tell me your name?
Timothy Borkins.
Mr. Borkins, you're on behalf of your cousin Eric English?
Yes.
And he's the representative of the estate?
Yes.
It's a complicated business you got here. The city is representing that you've agreed to reduce the fine from $49,200 to $7,380. Is that correct?
Correct.
And that'll be payable within 60 days?
Correct.
And you do understand that if it's not paid within those 60 days, it does return to the original amount?
Correct.
All right, in KCE 160-80352, I hereby reduce the fine to $7,380 payable within 60 days. Thank you, sir.
Thank you.
Thank you.
Oh, sorry for that.
Number 32, 413 North Sapodilla Avenue, CE 25073892.
Richard Pasmino, City of West Palm Beach Code Enforcement Supervisor. The property at 413 North Sapodilla Avenue has a lien code enforcement case. Case number CE 25073892 was cited for excessive overgrowth, dead vegetation, cut trim front, side, rear, overgrowth all over the property, clean and sanitary conditions, obstructing right-of-way, trees overhanging the sidewalk, tree trimming, outdoor storage, and paint. The code case was ordered on September 3rd, 2025, and was ordered to comply by October 3rd, 2025. On October 4th, 2025, the fine started running at $200 a day. The case was brought into compliance on November 25th, 2025, for a total of 52 days. Today, the fine amount in the case is $10,400. The city has come into an agreement with Mr. Chaim Moster, who's here today, to reduce the fine to $1,560 and requested that be paid within 6 months or 180 days.
Sir, can you state your name, please?
Chaim Moster.
Can you spell your last name?
Moster.
And Mr. Moster, you represent the owner, Prestigent LLC?
Yes.
The city is representing that you've reached an agreement to reduce the fine to $1,560 payable within 60 days. Is that your understanding as well, sir?
6 months.
I'm sorry, 6 months? Yes. 180 days, is that your understanding as well?
Yes.
Okay. You do understand if it's not paid during that time frame, it does return to the original amount?
Yes.
All right, in case CE 250738892, I reduce the fine to $1,560 payable within 180 days. Thank you, sir.
And that completes the agenda.
No further business before us. We are adjourned.